Good evening. Hello everybody. Apologies for not going live last Tuesday. So let's see here. Oh, what did I want to do? But here we are. I'm going to try out this funky new little feature to create highlights with this. So yeah. Okay, I'm not really sure how that works. Okay. So tonight's case study. Case study number 6. As I put in the description for the video, it's judicial misapprehension of the evidence and prosecutor mischaracterization of the evidence. So I talked about this in previous cases where prosecutors will actually take testimony and twist it around to something that it isn't, or they'll leave something out that's crucial, or they will just misrepresent it to the judge. And then the judge will use that evidence and convict. So the judge is also making an error. So we have both the prosecutor and the judge making an error. The judge compounds the error that the prosecutor makes. And this is a travesty of justice for so many obvious reasons. So mainly that a man's life is hanging in the balance because he's being charged with a very serious crime. Sex crimes have extremely serious consequences in Canada. Regardless of what people might think, they do. And even if you might think they might be getting a short jail sentence for the crime, well, you need to look at the context of the case. And often it is just a she said, he said, or he said type of claim. And it's a historical, it's of a historical nature where there's no actual crime scene to be investigated. There's no, trail of destruction or mutilation or, blood, results of a truly violent act, and which is what we would consider to be a real sex crime or real rape, right? Like things like that, are all the hallmarks of a serious crime, which of course that person, the perpetrator of that type of crime, will be sentenced harshly and rightfully. And he will have lasting, lifelong consequences of that punishment, aside from being in jail for many years. But in other cases, in more, pointing the finger at somebody and saying, they touched me, and or I didn't consent to that sexual encounter. Things like that. Regret sex, we fought while we were married and he raped me while we were married and I don't want him to see the kids. Type of, like, these kinds of things are more, the courts really need to tread carefully in these types of cases, and the police, but they don't. Some do, of course, but there are those that don't. And these are the cases that I'm highlighting. So if you're new to my channel, these are the cases that I'm highlighting to show that terrible things happen to innocent people in our courts. And the police, the prosecutors, the complainants, and the judges all just, want to get it all over with and, put the man in jail, give him a conviction, and move on to the next case. So here's a case where a prosecutor is being very careless. Now, is it on purpose? We can't tell if it's done with malice or not. But I've seen cases where this is common. It's not uncommon for this to happen. It's not uncommon for a Crown prosecutor to have it in their head that their sole goal for this trial is to result in a conviction. So they will do whatever it takes, even if that means misrepresenting the evidence or the testimony. So here we have a case where a conviction was overturned in 2016. He was tried and convicted in 2014, so it took about 2 years for his appeal decision to come through. And this was an Ontario court, Port Dover, which I'm not really sure exactly where that is, somewhere in southern Ontario, if I recall correctly. And it's a fairly short appeal decision, so I'll just go ahead and read it. On appeal from the conviction entered on May 2nd, 2014, by Justice S.R. Clark of the Ontario Court of Justice, sitting without a jury. So that's another component to this case, which is also very common in these cases, is it had no jury. It was a judge-only trial. All right, so the appellant was convicted of sexual offenses in relation to 2 young boys. He was found guilty of 2 counts of sexual assault, 2 counts of sexual interference, and 1 count of invitation to sexual touching. That would result in a very severe, long jail time. The boys were approximately 7 and 9 years old when the offenses were said to have occurred. The appellant appeals the convictions on the ground that the trial judge misapprehended the evidence. The 2 boys are brothers who were living with their grandmother. The appellant began renting a room in her home in early 2010. The brothers alleged that the appellant touched their genitals and buttocks and on one occasion showed them pornography. The older brother said that the appellant once told him to perform oral sex on him. When the complainant refused, the appellant masturbated next to him. Although there was a confrontation in the home about these issues in the spring of 2011, the grandmother took no action and the appellant was allowed to stay in the house, and no disclosure was made to authorities until later in 2013. Okay, so this is a man who's renting a room in a house where there's 2 little boys. That's the first mistake for this man. I mean, obviously, it was nice of this woman to be renting a room. She needed extra income, and she trusted this man enough to let him rent a room in the house. But in today's day and age, it's dangerous to be a man in a house with children, period. Even if they are your own, or your grandkids, or your nephews or nieces. It's just very dangerous when the relationship between the adults in these households go sour for whatever reason. Even later down the road, as in this case, it took 2 years. So the trial took place in the Ontario Court of Justice sporadically over a number of days in 2014. The boys, then ages 11 and 13, testified, and their grandmother and the appellant did as well. So the main issue before the trial judge was credibility, as is in all of these cases where there's no evidence, no crime scene, no physical evidence, no hospital records documented of any sort. It's just verbal claims, being made about something that may or may not have occurred. So when that happens, the trial judge's only option is to decide whose story they believe, ultimately, even though the courts and the lawyers and the judges will tell you that that's not what they're supposed to do. That's exactly what they do. What else are they going to do, right? Aside from not allowing these types of charges in courts in the first place, they basically give them the legal framework to allow them to choose a story they believe. So, the trial judge recognizes this, and he concluded that although the appellant was not unimpressive as a witness, he did not believe him. He found that the appellant's blanket denial of each event simply cannot be true. The trial judge relied on one specific example to ground his finding. The example related to the appellant's evidence about watching movies on a sofa with the boys and their grandmother. The appellant testified that the boys would lie on the sofa, one next to his grandmother and the other with his head on a cushion on the appellant's lap. The trial judge fastened on this and concluded that the appellant changed his evidence during cross-examination to add that there was a cushion between him on the boy that had not been previously mentioned. So, in fact, the appellant did not change his evidence during cross-examination. He mentioned the cushion in his examination in chief. Question: do you recall that everybody would watch a movie? Answer: I would sit at the end of one, like the long couch. The complainant would lay on the long couch with his head in my lap. Question. Would the complainant be next to you? Answer. Yes, prostrate, with his head on a pillow in my lap. Prostrate means flat, laid flat in this context. So by the time the appellant was cross-examined, the parties had received transcripts of the appellant's examination in chief. When the appellant referred to the cushion on his lap, the Crown suggested to him that he had not mentioned this in his examination in chief. Question. So now you're saying there was a cushion? Answer. Yes. He always had the cushion under his head. So the Crown pursued this line of questioning, suggesting that he had not mentioned the cushion before, as we know he did. This mischaracterization became the trial judge's main articulated reason for rejecting the appellant's testimony. At paragraph 94 of his reasons, he discussed the inconsistencies in the appellant's testimony and said this. The most obvious inconsistency relates to that part of his evidence where he stated that when they were all sitting on the couch watching movies, the complainant would lay with his head in the appellant's lap. He said nothing in his examination in chief about his head being on a cushion, but on cross-examination, he then must have realized that having a cushion covering his lap would somehow make it less suggestive of some form of intimacy. His explanation of not mentioning the cushion because he merely assumed that it would somehow be understood that this was the situation is an absurdity. This is the start of many parts of his evidence which exposes and undermines his credibility and reliability, leaving the court with the impression that he was making it up as he was going along, or, as the Crown characterized it, he was a moving target. Wow. Shouldn't the trial judge be reading the testimony transcripts? As it's stated here, they were all generated by the time the trial was over. So why aren't the judges verifying and reading through testimony transcripts before they come out swinging with cruel, insulting, wrong decisions like this? If you want to talk about incompetent courts, this is what we should be worrying about the most. Decisions like this, judges like this, and prosecutors like this. So the trial judge was mistaken when he said that the appellant said nothing about the cushion in his examination in chief. A misapprehension of evidence must be material to justify the court's intervention. And a bunch of cases are cited: R versus Hemsworth, R versus Lower, R versus Sinclair. All of these cases, judges explained that an error in the assessment of the evidence will amount to a miscarriage of justice only if striking it from the judgment would leave the trial judge's reasoning on which the conviction is based on an unsteady ground. This stringent standard is met in this case. So basically what that means is, if you were to take that issue of the cushion away from the decision framework that the judge used, would the judge have anything left in his reasoning to find a conviction? And since this appeal court found that this cushion issue was the sole basis of which he rejected the appellant or the convicted person's testimony, without that, the judge has nothing to convict with. So that is one of the things when you're looking at cases or wondering how you can appeal something. You basically have to deconstruct a judge's decision and pick the points of which the judge came to the decision with. And if you have an argument that will obliterate one element of their verdict, like in this case, the mischaracterized evidence representation of the cushion, testimony, once you strip that away, what else is left in the judge's decision that could still, reasonably result in a conviction? If there's anything else left, then you have to go to the next point that's left and do the same reasoning and look at the legal arguments or any mistakes made around that. And any type of legal, it could be anything. But if there's a way to eliminate that from the judge's decision, then you look again and see what's left. If there's nothing left, then you're going to win that appeal. If there's still something left, you could still lose that appeal unless you have an argument to remove that as well successfully. So in this case, though, the judge just picked one ground to come to a verdict on this case, and it's completely obliterated by the fact that the Crown misrepresented it and the judge misapprehended it, and it's been recognized by this appeal court. So the trial judge concluded, based primarily on the misapprehension of the evidence about the cushion, that the credibility and reliability of the appellant's testimony was undermined. He noted that some of the inconsistencies in his evidence were rather glaring, yet he only referred to the cushion incident. So going back to what I was just saying, if there was another piece in his verdict related to his reliability and credibility, for example, a consistency that he specifically laid out, if he were to actually have laid out what one of those inconsistencies were, that could still lose him his appeal. Hold on. Sorry, 1 second. Okay, had to let the cat out of the room. Anyway, so the appeal court is very clear in that, which, if you understand how these things work, it really helps to understand when people are trying to put an appeal together. It doesn't matter who you are, whether you're a lawyer, an advocate, an appellate yourself, a friend trying to understand, how to help somebody. It doesn't really matter who you are, but you really need to read these verdicts over and over and over again and really pick them apart and understand, and which is what I do, and that's why I have this channel. So, just keep coming back to my channel and I'll just keep doing this for you. So anyway, let me just wrap this up here. So during oral submissions, the Crown referred to other inconsistencies, but we find none of them significant or glaring. Okay, so the appeal court is saying that the judge did not refer to any inconsistencies, but the Crown did, but the appeal court, whatever. So on the hierarchy, if the judge had an inconsistency, then the appeal court would have to take that very seriously. But then down as the next level is the Crown came up with some, but the appeal court was not convinced at all. It's nothing. So the main issue for the trial judge was credibility. His conclusion as to the credibility of the appellant was tainted by an error of fact. The error infected the core of his reasoning on the credibility of the appellant. Consequently, the convictions cannot stand. The appeal is allowed, the convictions are quashed, and a new trial is ordered at the discretion of the Crown. So as far as I can see, a new trial never occurred, which meant the Crown either withdrew the charges or stayed the charges. Most likely stayed, because Crowns don't like to lose, and withdrawing is a complete retreat, it's completely conceding from the case, whereas a staying is I may not be done with this. So, those charges will still stand for a year, and an acquittal is never entered. And unfortunately, again, I've said this before, it's not the optimal outcome in a case like this. You want the appeal court to enter an acquittal, quash the conviction and enter acquittals. They didn't in this case. They left it open for a retrial. The retrial never occurred, so the charges are still just kind of hanging there above his head for a year, which means that the Crown could reopen it for whatever reason. So obviously they didn't, because this case still stands, this decision still stands, and in fact, it has been cited 0 times for any other case, which is unfortunate. Because it's a good case, actually, for when crowns misrepresent and misapprehend evidence, which does happen. I've seen it. I've read it in cases myself. And then the judges just compound that. So again, this goes back to why didn't the judge in this case go back and read the actual testimony transcript of the appellant to look for any evidence about the cushion? Shouldn't that be mandatory? If the judges, and we know that trials occur and then month, 2 months, 3 months later, they will come out for a decision, with a decision. So you have to wait months for the trial judge to come out with their verdict. So they have all that time to study the case, write out their verdict, and make sure that they have all the facts correct. And in this case, they didn't. And this appeal court, though, did not reprimand the Crown at all, which I don't understand. But the Crown should absolutely be reprimanded as well, because the Crown is equally just as responsible and accountable for making sure they are not misapprehending the evidence. So if you're curious at all about the judge's verdict in full on this case, the actual trial verdict that led to the appeal, that also exists, and I linked to that in the description bar in this video, so you can click on that, and you can read the trial judge's decision in its entirety if you're curious. It's actually a fairly lengthy decision, so I know that the trial judge in this case spent months and spent a lot of time writing a completely bullshit decision, and his sole reason, after writing out all of this, by basically saying the defense denied this, the defense denied that, the boy said this, the boy said that, the grandmother said this, the grandmother said that, but the defense denied, blanket denials, blah, 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 blah. And in the end, it just all came down to this cushion, which is right here, referred to in this one little paragraph here. And then again here. And he didn't get it right. The judge got it all wrong. So it's really, as a Canadian citizen, as just, you know, a regular plebe, it's really disheartening to see that our courts are this incompetent, that we even allow it to happen. And then, you know, in an appeal decision like this, it doesn't even reprimand the Crown at all for what was obviously their mistake first. And even if you don't want to put the full blame on the Crown, at least later, the Crown would have had a chance to actually correct the judge on that testimony, because it is still, the Crown is still accountable to making sure that the accused person gets a fair trial. And that does include catching any mistakes that the judge might be making, even if it isn't to the benefit of the Crown winning a conviction. They're not supposed to be there just to win a conviction. That's not their mandate. But yet, this is obviously how the Crown in this case behaved, and, you know, was happy to see the judge convict. So yeah, the trial judge, the trial decision in its entirety, I don't even know if you want to read it, but it's, you know, it could be a learning experience. Now, another thing that has me concerned here in Can Lee is, okay, so this is the trial judge's decision, and see, it says here cited by 0 documents. That needs to be remedied. It should at least be cited by 1 document, and it should be cited by the appeal decision here. They need to be linked. These 2 decisions need to be linked, but they're not. So anybody doing research on sex assault cases, make stumble upon this trial judge's decision and not know that it's been overturned unless they dig a little deeper. But that's another thing that, so this decision can just sit there in this database, available to the public and to crowns, attorneys, and be perpetuated as a successful judicial conviction in a sex crime case that could be perpetuated in another case and in another case. And people are so incompetent these days, don't even take the time to do research and verify things, that, you know, this may never be known to have been overturned. So this is very concerning to me. And that's a gripe that I have when I'm doing research in these cases, is that they're not properly linked throughout the, throughout its lifetime of related decisions. So anyway, so yeah. Hi, Fillerator. Okay, I'm going to pull out the chat window here. Just give me a second. I always have a little... Okay, let's see. I'm just going to pull it up like this. All right. Fillerator, you couldn't stay tonight. Yeah, well, sorry you weren't able to stay for the live show, but you'll be able to watch it later, no problem. So, yeah, just don't forget to upvote it. And Simon Ford may want to look at cases of individuals convicted due to fear. In New Zealand at the moment, the police and government are going overboard. If you're talking about the mosque shooting and fears in terms of terrorism and white supremacy and things like that, yeah, well, that's a whole other category that I don't really do content on. It's not really my area of study. I might comment it on, Twitter or something like that, but as far as my content, I just focus on sex crimes mostly, pretty much. Sex crimes and court cases that involve no evidence, and in that case there is evidence as far as I understood. But anyway, regarding the fear thing, well, if you spend some time and watch some of my channels, watch some of the videos on my channel, all of these sex crime laws that we currently have in place now are in place because of fear and moral panics that have occurred in cycles over the last few decades, thanks largely, in most part, to feminism and feminists, people like Gloria Allred. She's a huge spearheader of this whole movement to change the laws in Western legal systems, in common law legal systems such as ours, Canada's, New Zealand's, Australia's, US, Hong Kong, other countries around the world. And I've even noticed recently, I've stumbled across an interesting channel actually on YouTube from a gentleman in Kenya who calls himself a journalist, and from what I've seen, he does pretty decent journalism in his YouTube videos. He does excellent, well-spoken, well-thought-out analysis on cases. He does a variety of situations, such as the Boeing 737 MAX 8 issues with, their airplanes falling out of the sky within a short period of time, and analyzing the how the media is sort of portraying that versus what's actually happening versus what most likely the conclusion will be, and also sex crime cases. So apparently they have the same problem in Kenya, where hysterical women are able to use the justice system, the police and the justice system, to punish and lock away a man that they're angry at for something other than any actual alleged abuse. But the claim is sexual abuse, whether it's against the mother of the children or the children themselves. It happens in Kenya. They have the same problem in their court system. I have not studied their court system, But I do not know what type, if it's a typical common law court system like ours, the Western common law, but it sounds like it is. Logic MK. One would think there should be a time limit as to how long a crown can keep a case in limbo, say 6 months or a year tops. Well, I think there is actually, if you're talking about, like in the case that I just discussed, if you're talking about how long a crown has to decide to proceed with a new trial after an appeal court has called a retrial, they have a year, basically. So that's their time limit. As far as judges making their decision, that has nothing to do with the crown. That's solely the the judges need, for whatever reason, that all that extra time to write and release their verdict. And all of the other puzzle pieces have to fall into place and into everybody's schedule. The defense lawyer, the crown, and the judge all have to agree on a schedule that they can all sit in court for the same day to hear the verdict. That's another thing. So it's not always the crown's fault. They do have limits imposed on them. If you meant something else, let me know. But Simon Ford, an excellent case here in the past was Ellis, who got convicted, a gross miscarriage of justice. I don't know who Ellis is, but feel free to leave more information on a specific case. And Deep Purple, thank you for doing these videos. You're very welcome. It's an important service. What can I say? I can't not do these videos. I may have times where I'm not going live when you might expect me to. I may not be pushing out content as often. I may do it in spurts. But, you know, I have other things going on that take up my time, and doing content and taking the time out or being in the mind frame to do these things sometimes doesn't always fall into place. But it's always something I'm going to be... I can't imagine not doing this content, doing these videos. I do intend to progress developing the database for all of the overturned convictions that I have, to make it accessible to the public on a website. That is a goal that I have. And writing a book, that is also a goal I have, which I am in the process of putting together the skeleton for that, for the table of contents, and trying to organize the content and how I want it to look. I don't want it to be anything, you know, major, like, you know, a book this thick or anything like that. I don't want to focus on any one person's story. I want to put together like a cohesive chronology of sex crime cases and how many innocent lives are destroyed, not only by false allegations, but by wrongful arrests, wrongful charges, wrongful prosecutions, and wrongful convictions, how we got to where we are, how it affects other countries, how the same things are happening in other countries, the common denominators in all of these things, and really highlighting wrongful overturned convictions, you know, convictions that have been overturned, to show that there are many, many of these that exist that nobody knows about, to counter the hysteria, you know, that's been occurring, that not enough convictions happen, people get away with conviction, with being, you know, people are getting away with being criminals in terms of sex crimes. They get off too easy in court, yada yada. You know, like it just doesn't happen. Not to the extent that innocent people are actually being wrongfully convicted. I would say that happens way more than anybody getting off easy on a technicality, so to speak. I think that rarely happens in relation to how often an innocent person is convicted and having their life completely destroyed. Because once you're convicted in a she said, he said type of case, it is damn near impossible to recover from that and to get out from underneath that, because you don't have any physical objective evidence to argue, to say that it was misrepresented or it was the science was wrong, or, you know, the science is new or updated, or, you know, you don't have anything really specific to argue, DNA, blood, evidence, things like that, right? Like, these things just don't exist in she said, he said cases. So it's just damn near impossible to overturn. So, you know, these cases that I am highlighting that have been overturned are very fortunate to have been overturned. Not all wrongful convictions are overturned. That's another problem. So, you know, in this book that I want to write, that I'm trying to put together, I do want to highlight convictions that are still standing, that never successfully were overturned, but let the reader and the viewer of these cases understand for themselves what people are being convicted, on what basis people are being convicted. Simon Ford. Ellis was convicted working at a daycare center who was accused of satanic rituals and interfering with children. Children coached after Scotland hysteria with satanic rites. Okay. Sorry, I was unfamiliar with that name, but I'm very familiar with these types of cases. I know there were many of them. I'm assuming this case you're talking about, yeah, is specific to Scotland. Well, there were many cases in the US, there were many cases in Canada, many cases in UK, and these types of cases are still occurring, except just minus Satan, just minus the Satan aspect. But overall, it's all the same. You know, oh my God, you know, a child daycare worker molested all of the children. It's just, you know, minus the Satan or eating babies aspect now. I mean, it was even crazy then that people would actually believe this stuff, or courts would actually take these types of things seriously. But obviously it made it out into the public domain. So attorneys, prosecutors, you know, people realized, okay, well, if we're going to run these types of cases through the courts, we need to get rid of the satanic aspect of it, the satanic ritual, eating babies, killing people type of thing, because that's just way over the top and the public just ain't going to buy it. So they did. They dropped that aspect of these cases, and now it's all about post-traumatic stress disorder, or repressed memory, or recovered memory, or having always remembered but chosen to forget, until, of course, you go see a therapist who helps you come to terms with what you've been denying all your adulthood. So it's still the same playbook. It's just the script has been updated to the current times. So we're still seeing a lot of these hysteria type cases in our courts. And it, you know, I just want to say that it really bugs me, because when I do talk about this to people, either in real life, you know, outside of social media, or in social media for that matter, often I hear a comment where people will say, yeah, but hasn't repressed memory, that was debunked a long time ago. Nobody does that anymore. Nobody believes that kind of stuff. It's, oh, yes, they do. It's just, I think maybe people still sort of associate repressed memory with satanic rituals and eating babies and things like that, which is so over the top. Of course, that's just, you know, no one can believe that. But I guess it becomes harder to explain, where, well, it's the same playbook today. It's just that, you know, remove the satanic and the babies and all that stuff, remove all of that context from it. And now it's just been repackaged and relabeled, you know, as post-traumatic stress disorder, people having drug addictions, because they were abused as children, and that's proof that they were abused as children, because they're addicted to drugs, they're alcoholics, they can't keep their jobs, they're beating their wives or their husbands, or their kids or whatever, and all of this somehow, you know, the fact that that person themselves is displaying criminal behavior or borderline criminal behavior or psychotic behavior, that in itself is almost like saying they are Satan. They have satanic characteristics, which somehow is evidence that they were abused. So it's really hard to make sense of that even when I say it myself, but that's pretty much where we're at today. So Roscoe says, make distinction between the Crown as prosecutor and the judiciary regarding statute of limitations on appeal and judgment, reserved decision judgment. I understand there is no time limit on reserve. Yeah, so reserving the decision for the judge, there's definitely no time limit as far as I know. But when it comes to the Crown or the prosecutor, with statute of limitations on appeal, yes, there is a time limit for appealing, but that goes for both sides, for the defense or the prosecutor or Crown. I hope that answers or addresses your comment, Roscoe. Feel free to add to that how you wish. Logic MK. The battle always lasts years in sexual assault cases. It's completely unreasonable as to how slow the process is. Yeah, it is. I know people who've taken, they've been fortunate enough to deal with it and wrap it up within a 5-year period. That still seems like a long time though. But there's other people, it's been like, 8, 10 years. Could be longer. Martinsville. Oh, yeah. Martinsville, SK, Saskatchewan? Oh. Yeah, it's the everywhere, unfortunately. I really do consider it a legal industry that's created by lawyers, because it keeps them busy. It justifies turning out all of these new law students out of very, very expensive law schools. As long as there's crime, even if it's just manufactured and made up crime, and you have other actors who assist you with that victim and crime manufacturing, i.e. therapists, psychotherapists, these types of cases people will always be susceptible to, having these types of, being involved in these types of cases. Doesn't matter who you are, doesn't matter how clean you are, doesn't matter how Pollyanna, if you will, you are, doesn't matter, if you've never even had a speeding ticket. It doesn't matter. Anybody, if you're a male, you're susceptible. Even women are becoming susceptible to claims these days, So nobody's really immune to this kind of thing, unfortunately. And I'm sure give it another generation or two and these sex crime cases will still be happening, but under a different, in a different era, like a different air of different ingredients, basically. So at one point it was satanic rituals and eating babies and, going to ritual sacrifices and things like that. At one time it was that. We wouldn't even dream of entertaining such a case nowadays. So I wonder what it'll look like in the next generation. Therapist equals hired gun. Yeah. Well, but Sean, there are people who legitimately go to see therapists because for various reasons, right? They're having problems in life because of depression or bipolar or some sort of, mental instability, which could be very well temporary for whatever reasons. They could be caught up in a drug addiction loop, alcohol, bad relationship, caught up with the wrong person, whatever. That could just bring out the worst in them. And they've decided they needed to go see a therapist. These are all reasonable reasons. You got to commend them for that. But what they don't know is that they might be stepping into a lion's den, or a snake pit, I really should call it, since, these people are snake oil charlatan types. And they've already targeted their new client as a, potential child abuse victim, but they just don't know it yet. all these problems that they have with life right now exist because they were abused as a child, but they don't know it. And it takes a few sessions for these snake oil charlatans. Whether they're, these sessions are paid for. They're getting paid for these sessions, whether it's by an insurance company, a employee benefits plan, or out of pocket, or even a government plan. These therapists are getting paid no matter what, and the longer they can keep these clients coming in, the longer they get paid. What's the best way to make sure these clients are continual repeat customers? They come in every week on a regular basis for an extended period of time. Well, you got to work on their entire profile, their childhood, go all the way back. It's called regressive therapy, or regression therapy, regression tactics used in these therapy sessions. And before you know it, you've got a person that's going to start believing, because they're so desperate and they're so vulnerable. That's the main thing. They're already a vulnerable being at this point. They're very vulnerable. And they're going to be so desperate to grasp onto a reason why all of these things, all these problems exist, why everything just keeps going wrong in their life. And when you're in such a vulnerable state like that, and you see a charlatan snake oil therapist like this, they know how to tinker with the brain. And they will eventually have you, or these people, believing that all of it's a simple solution. All of these things are happening to me because of something that happened to me when I was a kid that I forgot about, or I didn't think about, or I didn't realize was something that would lead me down this path in my adult life. Simple as that. Drugs and alcohol, dementia, of course, is never the problem, even though it's proven to create serious mental health issues. Can't blame others for what you put in your body. Yeah. We don't want to blame drugs and alcohol or other brain issues, memory issues, brain injuries, degenerative diseases. We don't want to blame any of that on, possibly the reason why somebody's coming up with this crazy accusation. Never. No. Jamie Watson, how will Section 276 of Bill C-51 affect this? In this particular case, I don't think it would have any effect. The new provision, I'm assuming you're talking about, where any digital communications must be given or presented to the judge in a separate hearing to determine if it can be admitted as evidence, which by virtue of doing that discloses your defense theory or defense strategy to the Crown and the complainant. So in this case that I just discussed, in a sample like that, I don't think there was any communications involved, digital communications regarding any incidents, at least not that I know of. So there will be many cases where it just won't be an issue. I don't really know, for appeals, I mean, in sex assault cases. Oh, that's a good question. For appeals, well, I guess it would be like in any record production scenario, because it has to be a separate hearing. So you can appeal the decision in that hearing. That is always a possibility if you don't like the decision. If the decision does not work in your favor, you can appeal it. And I would assume the Crown could do the same thing. Now, I don't know how often that happens, because this is a mid-trial type of thing or a pre-trial type of thing. So I don't know how likely that would happen. But let's see. After a verdict is made, and a defense lawyer or an appeal lawyer examines the case and examines the record production for the digital communications, and the outcome of the hearing, and if they find any errors in that hearing, just as in the regular trial, that can be form the basis of an appeal, just like any other procedure. I hope that answers your question. Just a thought, says Sean Northern. One of the first things a good therapist should be doing is contracting with their clients to leave therapy. Sounds kind of odd, but it stops the kind of bullshit you are describing. Good. Contracting with their clients to leave therapy. What do you mean? Jamie, charter violations. Yeah, we won't know until... I haven't actually looked to see if there's been any appeals involving the new provision. We might have to wait a little longer to see if anything has made it as far as a charter violation. But basically there's no case law on charter violations, so I can't really make any... with respect to this new provision in the appeal context. As long as there's no case law, I can't make any comment on that. We just have to wait for case law. Unfortunately, that's how our system works. I don't like it, personally. I think the entire system needs to be burnt down and start over again with a basic, thin little manual of basic crimes that need to be proven in a court of law with no case law bullshit. Contracting to leave. How long are we going to do this therapy thing? Oh, like setting a time limit. Yeah, I don't know. I myself, I've not sought therapy. Well, actually, that's not true. I did once, many years ago, with, it was like a couples counseling thing. We, I think, had maybe 2 sessions or something like that, and it was just like, nah, that's not really helping us. I don't know. I mean, I think people in general, they go to see a therapist either because it's something they need to fulfill for their employment benefit contract, like, we won't fire you if you go get therapy kind of thing. I know that exists. And we can't fire you until after you've gone to get some therapy for X amount of time kind of thing. And then after you've done your therapy and you want to come back to your job, then we can reevaluate performance issues. I know that's in place. But as far as just a regular person who goes in with, just on their own volition to see a therapist, I can't imagine what that would be like to go in and just say, I only want to see you for 3 months, and by the end of it, I want to be completely healed, or I want to know how to get rid of this depression. I really don't know how that would work. But however, having worked, volunteered for a center that did organize volunteer therapy sessions for people for their clients, I did talk to a lot of people who were seeking therapy, and often it was just they were in the middle, smack dab in the middle of a very low period, and they wanted some help, but they didn't want to have to pay for it. They didn't have the means to pay for it. They just wanted to reach out, and sometimes just sitting in a session once with somebody was enough for them, because really they just wanted to talk to somebody in private in a room that wasn't going to judge them and just listen to them and let them talk. And sometimes these people, that's all they wanted was just that one session. But sometimes they'll come back and see them maybe 2 or 3 times total. I find for the most part, I think a good therapist is one that doesn't lure you to come back or make you feel obligated to come back. I think that's a good therapist. The charlatan snake oil ones, which they're not regulated, that's the other problem. Ontario and Canada in general has no regulation for therapists, psychotherapists. I mean, it has regulations in terms of not abusing their client. Like, being physically abusive or sexually abusing their client, which is standard fare currently across all of our professions. But what they don't have regulations for, which I think is wrong and needs to be addressed, is the types of therapies that they practice on a person that is so vulnerable. And as you say, maybe having time lengths or having some sort of contract between the client. There probably is a contract, but it's something you sign that just says, I waive, I waive my ability to sue you. Basically, it's probably just a waiver to not sue your therapist, to absolve them of all accountability if your therapy doesn't work for whatever reason. But you do bring up a good point, because therapists will want to work with you on what your goal is, but it takes two to tango, right? Like, it takes a reasonable person to know that they have a goal that they want to work towards. Just getting rid of my depression is sort of a goal, but maybe you need a more concrete goal. And if you're a reasonable person and you're just having a tough time, you just need someone to hold your hand for a while. And the therapist themselves is a reasonable person who can, pretty quickly identify, because they've done this over and over and over again in similar scenarios with different people. So they know what works, they know what doesn't work, depending on that person's particular issue, right? So, the problem is we do have therapists that are reasonable, but we have that are, just like talk therapists that will help you work towards a goal. Then we have life coach type therapists, which I think maybe are a safe type of person to help move you forward and remotivate yourself. As a life coach type might be safer, because they are hyper focused on setting goals, like getting a job or getting that promotion, saving up enough money to buy that house, losing weight, fitness goals, jogging. And they'll call you and say, did you jog your 10 miles today? Did you ask your boss, did you set up that promotion meeting yet? Like, those types of goals, and having a life coach, somebody on you for that kind of thing, I think is, if you need that, I think I could see how that would be helpful. But the problem with these charlatan snake oil therapists, like Lori Haskell types, who's always in CBC giving these disgusting interviews, and she's always being quoted as some sort of expert and trainer of police and judges and attorneys, which is very scary. But she takes the snake oil approach that people have problems, they just don't know what the source of their problem is, because they need to see therapy. They need to have ongoing, regular, therapy sessions to help regress back into their pasts to see what brought them to where they are today, which is a very different way of dealing with somebody who's having motivational issues and just moving forward in life, because ultimately that's what we all want. We all want to move forward in life. And when you have somebody that's constantly trying to bring you back, that's bad. That's really bad. That fucks people up. There should be regulations for that, as far as I'm concerned. Regression therapy should be illegal, as far as I'm concerned. I kind of went off on a long tangent there, didn't I? Yeah. Counselor and psychotherapist are regulated titles. Sure, the titles might be regulated, and you have to have certain hours and credentials and whatnot. But the actual things that you do in the privacy of your own office are not regulated. So there you go. Yeah. Sean Northern, I see client for about 6 to 8 sessions. Oh, are you a therapist, Sean? I did not know. Some kind of life coach or therapist or something? Okay, so yeah, so 6 to 8 sessions, I guess you would say, is kind of standard, and then they just drop off, and they felt like they've gotten what they've needed. They've reached a point, where they've gotten what they've needed, and they're able to move on. So that's great, that's great. So it's the charlatan snake oil therapists that, you know, they want you to just keep coming back for maybe a couple months or so and work on you. But I mean, even within 6 to 8 weeks, they can still regress you backwards to a very dangerous point where you're believing things that aren't true. It can still happen within a short period of time. It really depends on how vulnerable that person is as well. And obviously, if you're going to seek help, you're vulnerable. So yeah, men are screwed now. Yeah, it's true. I'm so sorry, you know. What can I say? But by extension, the women in your life are also screwed, you know. Your future girlfriends or current girlfriends or wives or your daughters or your sisters or mothers, cousins, aunts, grandparents, you know, women are also screwed by this. It's not just men. I mean, men are obviously on the firing line here. But it's just bad for society as a whole, is my point. Logic MK. My friend had a niece and son go see a therapist for their issues. In both cases, the therapists went right for sexual abuse. Yeah, see, a lot of these therapists will go for it as soon as the first visit, maybe the second visit. Yeah, so the son lost it on the therapist for perusing a bullshit topic that he was clear never happened to him. Well, good. So he was obviously not that vulnerable in that sense. And the niece was drugged and hooked. It was not pretty and led to someone being falsely accused. Fortunately, he was cleared. That's so sad. It's really, really unfortunate. And I bet you in most of these overturned conviction cases that I'm reading to you, there is a therapist element hiding behind it somewhere. And for various reasons, they meant that particular contextual element never makes it into the cases, or at least is only a tiny feature, a very small feature of a case, but one that nobody really focuses on, when I know that should be a huge focus. Yeah, it can split an entire family when these things happen. It's really terrible. Well, on that note, guys, if you have any other questions, I'm going to close up. It's been an hour, and it's been a good talk and an interesting case again. So yeah, and if you are watching for the first time and you haven't subscribed, please subscribe to my channel and like and upvote the video. And yeah, get notifications for when I do upload new content, when I make other videos outside of the stream. And otherwise, stay tuned for the next stream. And everyone, thank you for joining in tonight, and have a lovely evening.